Hi guys, this is Erica from Gokce Capital.
Now before I begin, be sure to subscribe to our YouTube channel and turn on notifications. All roads lead to Rome, correct? Perhaps. But imagine you were a farmer living in the outskirts of the Roman Empire in Britain. Do you really think that even an empire as vast and wealthy as ancient Rome would be able to build and maintain public roads to every farm in your region? Most likely, the only way that you could get to market would be through taking your horse and cart through your neighbors' farms. For your ancestors in the past, perhaps this was not a problem, for prior to Roman control, your family may have simply farmed for subsistence purposes and rarely would have needed to access the nearby village. But now Rome, along with what security improvements and infrastructure it may be providing, is also requiring you to pay tax in the form of produce delivered at the local village. Now access to the market has become much more important, both for you and for the Romans who depend on your grain to feed their towns and armies. But what if you get in a dispute with your neighbor? Say your teenage son, bored with life on the farm, decides to relieve his boredom by stealing your neighbor's horse, and enraged your neighbor ceases to allow you to pass through his farm. What will you do? How will you get to market, and how will Rome get its grain? Well, ever practical, the Romans had a solution for this. They created an obscure legal concept called a servitude, which has passed down through the ages and is still in use today in the form of an easement. And even in a country as built up as modern America, there are many parcels that rely on easements to provide access. But easements are still subject to the whims of human nature in a way that a public road may not be. So if you have always relied on public roads for access, and have never had to contend with an easement, take a moment to think about some of the situations that can arise when you have two, perhaps strangers, negotiating access and property rights over a long period of time. One story in particular that I heard from a property owner stands out for me. And this was a property owner who had recently bought a rural ranch. And the driveway on the ranch up to the ranch house had an easement on it that allowed a nearby HOA to use the land for access to a community space bordering a nearby pond. But shortly after purchase, the HOA began blocking the pathway and harassing the property owners. How is this possible? And is there any recourse? I'll go over this later, but before I do, I did want to cover some of the top things you ought to know about road easements, whether you are someone who owns or is looking to purchase landlocked property that needs an easement, or if you are a property owner or a land purchaser who is buying a property with an easement on it. Number 1. An easement is the legal right of a non-owner to use a part of another person's land. In this case, the use would be for access purposes. Number 2. An access easement is needed when there is no legal right-of-way. So generally, this means there's no public road fronting your property. Number 3, perhaps the biggest question you may have is, how do you know whether there is an easement either on my property or, in the case of a landlocked property, leading to my property? Well, an easement should be recorded and thus be of public record. You can therefore do your own initial search through public documents to check for language conveying an easement. The first place to look would be in your property's deed or the deeds of the neighboring properties. There may also be a standalone recorded easement agreement, so you'll want to check public records for these kinds of agreements as well. Other documents that may contain easement agreements include HOA CCRs and deed restrictions. Since easements can be written into a number of different documents, perhaps the best course of action is to order a title search and have the title company do the research for you. However, should you be undertaking this search yourself, I'll show you an example of what to look for. This is a sample deed, and if you read this line here, it says that the property is subject to the rights of all present and future lot owners in a particular subdivision to use a strip of land for ingress and egress to the Cacapon River. And so this is the kind of language you would be looking for when you're doing your search for easements. Number 4, if you have bought or are buying a landlocked property, how do you go about creating a road easement? The easiest way to do this is through an express easement, which involves working with the neighboring property owner to grant an easement for access purposes in writing. The first step will be to reach out to the neighboring property owner and discuss the terms of the easement. You can then have an easement agreement written up by your lawyer, have it signed by your neighbor, and then file it in the county records. I will just note that the neighboring property owner will likely require some kind of compensation. Number 5. Also keep in mind that there are easements that can be created by law, even if a formal agreement is not created between you and your neighbor. These sorts of easements arise out of specific circumstances, and the exact legal requirements that must be met will vary from state to state. So before considering any of these kinds of easements, consult with a land use attorney local to the property in question. The first of these easements by law is an easement by necessity. Such an easement may be created if the owner of a landlocked property can prove that their property and the neighboring property were once jointly owned, and that at the time of subdivision, an access easement would have been necessary to provide access to the landlocked property. Another, perhaps more common example is a prescriptive easement, and for anyone familiar with adverse possession, this is very similar in concept. If the owner of the landlocked property has been using a neighboring property for access openly and continuously for a set time period, and they did not have official permission from the neighboring property owner to use their property for access, then a prescriptive easement may be created by law. And finally, there are certain circumstances where an easement by estoppel can be created. An easement of estoppel may be awarded if an owner of landlocked property can prove that at the time of purchase they were given false representation by the neighboring property owner, stating that they would be allowed to use the neighbor's property for access, and that this representation was relied upon to purchase the property. Number 6. An access easement can only be used for the purposes outlined in an easement, although easements can be modified to fit changing needs. This is an important concept because I've heard many property owners complaining that easement holders have been using their easements in ways that were not strictly speaking laid out in the easement agreement. However, having said this, while easement holders may only be allowed to use the easement for the purposes that are outlined in the agreement, keep in mind that easements, though they are a form of property right, function a bit more like a contract. That means that as an owner of a property with an easement running through it, your ability to force an easement holder to cease using the easement in a way that you believe is contrary to what is outlined in the agreement will only be as strong as the language in the easement itself, or as strong as your ability to enforce your rights as the property owner. This is why in practice you may hear horror stories about unneighborly neighbors taking advantage of easements. Which brings us back to our opening story. What happened in this circumstance? As it turned out, the property owners discovered that it wasn't the HOA who was granted an easement on their land. They, in fact, were the ones who had an easement allowing them to use the HOA's private road to access their property. Unfortunately, this meant that the HOA was the legal owner of the driveway in question and had certain rights to block the driveway or otherwise restrict access so long as the property owner could still use it to get to their home. Now, this story stuck with me because the owner in question had purchased the property with title insurance and had a title search done, yet the fact that their driveway was not legally owned by them was not disclosed or caught by the title company. Neither was it disclosed by their seller. In a circumstance like this, it is not clear what more they could have done in their initial due diligence prior to purchasing the property. And sadly, it just highlights some of the complications that can come with easements and landlocked properties. Do you have any stories about road easements? Let us know in the comments. Did you like this video? You're going to love our Gokce Land Due Diligence program. We'll make you a land due diligence expert in just 7 days. Check it out at gokcecapital.com/glad. And while you're at our website, don't forget to explore our $1 down properties at gokcecapital.com/listings. Finally, don't hesitate to reach out with any questions. You can email, call, or text, and we will respond as soon as possible. So thank you for listening, and more to come.